Good morning, everyone. My name is Kelly McKeon, and I have the pleasure of interviewing Rafi Podolsky today. It's November 25th, 2013, and I am conducting this interview as part of the Connecticut Bar Foundation's James W. Cooper Fellows' History of Legal Services in Connecticut project. So, Rafi, why don't you just start and tell us a little bit how you got into legal services? When did you start and where did you start, and then we can go from there.
Okay. Should I talk to the camera or should I talk to you?
You can talk to me or the camera, whatever.
Okay, well, I don't know which one. I started law school in 1969, and I pretty much knew at that time that I wanted to go into some form of public interest law. And I think I kind of thought it was going to be public service. I may have thought about public defender's work, but I'm not really cut out for criminal defense. It's, I think, a little more tension than I would like. Too much responsibility for people's lives. I went to law school at Yale. I started in 1969, and from the very beginning, I was exploring the possibility of doing some kind of legal aid work. There was a clinic at Yale, and at that point, I was actually out of college for 4 years. I didn't go straight to law school, and so I also was supporting myself at that time, and it kind of started. Excuse me, that I went to the financial aid office because I was running myself out of money, and I was trying to get essentially scholarship to supplement what I had, and they basically said, go get a job. They kind of said, we'll give you some grant, we'll give you some loan, the rest is for you to cover. So I was interested in kind of clinic work, but I discovered that if I went directly to New Haven Legal Assistance, they could actually hire me. And so I think I was one of the few clinic students who actually got paid a small amount to work. In any event, so I ended up starting with legal services in New Haven. It would have been sometime in the middle of my first year at law school.
And then you worked the rest of your law
I worked the rest of my law school for New Haven Legal Assistance, including during summers. So I was like 15 hours a week during the school year, and then more or less full-time during the summers. It was great for a number of reasons. The first year, I started out in the New Hallville office, which I don't think exists anymore. And I was supervised by Ed Dolan, and I'm trying to remember who was there. I think Tom Cordino was there. Both of them are now judges. I think Frank Cochran may have been there, but my memory fails me on a lot of the details. And then I worked, one summer I worked at the Legal Aid Bureau. Frank Deneen was my supervisor. And when I started, one of the nice things about legal services was that they gave a lot of responsibility to law students. And so in the 2 years or 2.5 years I was doing this, I really had a little practice of my own. I did welfare for hearings, I did unemployment comp hearings, I did some Social Security. These were things you didn't have to be a lawyer for. Right. And in theory, I was heavily supervised. In practice, I was, largely unsupervised. So, and I'm sure I did a lot of things wrong, but kind of the defining thing for me during the whole time I was there was that I ended up being the organizer of a rent strike that we just kind of backed into. There was a group of 12 tenants who lived on a street near downtown New Haven. They were very decent people. They were good tenants. They paid their rent. They did everything you were supposed to do. And the property was owned by somebody who did not manage the property well. And so they came to us. We ended up getting the whole group together. They formed a tenant association. They set up a structure, and they at some point, fairly early on, started withholding the rent. And I was the de facto treasurer. They paid it to us. As it turns out, I had the foresight to put it into a bank account in Massachusetts, which became important when somewhere in the process of this case, which extended the whole time I was working there, they got a lawyer named Bill Shore, who it turns out went on to a certain amount of fame as a lawyer for Lowell Weicker in connection with the Watergate investigation. And they decided that Ed Dolan and I were essentially engaged in tortious interference with business rights. And they sued me and Ed in New Haven Legal Assistance. And in those days, there was no due process, so that you did not have to go through a prejudgment remedy process. You simply sent a sheriff out to try and find assets and go to bank accounts. And you didn't know about it until after your bank account was attached. And as it turned out, that this Ed Dolan basically had no money. New Haven Legal Assistance had some kind of a demand note with the bank, so when they went to the bank simply called in the note, emptying New Haven Legal Assistance's account at that bank, and reported to the sheriff that there was no money. I, on the other hand, was a law student with a $400 checking account, and so I was the only one whose money was attached for the duration of that lawsuit.
Wow.
And that whole thing went on for a couple of years. It was finally settled at the very end. At one point, we lost. The eviction was based on a habitability defense. In the days before there was an established habitability defense. At one point, I wrote a brief on the right to jury trial in summary process actions, which somebody could still use probably. But in the end, the case was finally settled. So that was sort of like the defining theme for me through my time as a law student at Legal Services.
Great.
And I came. That was a law school class, by the way, that started with Hillary Rodham.
Okay.
And I made the mistake. Legal Services really was my legal life there, because having been out of school for 4 years, it was beneath me to live in a dormitory. I've been living in an apartment and that was a huge personal mistake, because that was where everybody made their connections. That's where you met everybody else who was in law school. And I didn't understand that at the time. And the result was I knew hardly anybody. I knew, I may have made a dozen connections, and not lifelong connections at that, but all these other people, who became famous.
They lived in dorms.
They lived in the law school dorm, so I never met Bill Clinton. What did I know? So in any event, the one thing that I actually, it was kind of interesting, because the summer that I worked with Frank Deneen as a supervisor was really remarkable. I don't know if somebody's interviewed Frank, but Frank essentially was not in the office during the day because he was in court constantly, and so if you wanted to talk to your supervisor, you basically were not going to leave work before, say, 7 o'clock, because you had to wait for Frank to come back at 5 or 5:30.
Right.
And I fainted in his office once.
Really?
Because I was
Tell
sitting.
us that story.
I was sitting. I was sitting at a desk. It must have been a metal desk. I don't know. And so he's on one side, I'm on the other side, and I'm sitting with my legs crossed and swinging my leg. And somehow I managed to bang my foot into the desk, and it ripped the toenail. And I don't know, maybe I was wearing sandals. I can't reconstruct how some of these things actually happen. And I look down, I see this blood, and I go,
oh god.
That's it. But those and the cases I did were really interesting, and they felt very good. In any event, after I graduated law school, I had other visions for myself. By then, having gone to law school, essentially to become a legal aid lawyer, by the time I got done with law school, I wanted to distance myself from the law as much as I could. And I actually apprenticed myself as a car mechanic, and that took about half a year before I gave up on that. And then I worked for the McGovern campaign. This was the summer of 1972, and then I started, or actually the sequence is, McGovern campaign came first. Then I apprenticed myself as an auto mechanic, and had visions of writing a book, sort of an idiot's book, an idiot's guide to how to fix my own car, and that didn't work out at all.
How come you felt like you wanted to distance yourself?
I think by the time I was, I enjoyed the legal services. Okay. I had very mixed feelings about law school itself. the things I liked in law school were in some ways not so much the laws, the stories. I loved Torts, because Torts was a series of
Right.
little vignette stories about problems people had and how they got solved, and in a lot of ways that was more interesting to me than sort of the
Right.
policy of the law itself. And I had my own kind of legal heroes, William Douglas's and Hugo Black and Skelly Wright. I wrote a long paper on Skelly Wright that I never finished.
Really?
I wrote it for Tom Emerson was my supervisor. I had this notion because I probably could have been a good law librarian or any librarian, but without appreciating how much Skelly Wright had written, I took on as a senior paper writing about Skelly Wright's view of the law. And to do that, you read his case, his decisions. Well, they're like hundreds of decisions. I read and I read and I read and I read. The voluminous notes and everything. But I couldn't get done. It's like you couldn't write the paper. And then I had to graduate. And I was forever grateful. I am forever grateful to Tom Emerson for letting me write like a 15-page summary of everything I'd read without ever pulling it into a paper. And he took that as a senior paper. And basically on proof that I had actually read far more cases than were being discussed in this paper. It was but then I was sort of ready to escape law school, and the McGovern campaign timing was right, so a year later is when I started looking for jobs, and the only place I ever looked for a job really was with legal services, and I eventually got hired to work at the Waterbury office, which was then, this is pre-merger of the program, so it was a separate office. And it was called the Waterbury Legal Aid and Reference Bureau, which was because it had derived from the old legal aid services, the old legal aid bureaus they used to have. And I started there in the fall of 1973. And the first thing that I actually learned was, I learned something about the culture of the different legal aid programs. The Waterbury culture was that basically it was a 9-to-5 job. And I was coming out of the New Haven culture, which was, you stay there till you get done, it doesn't matter how late you stay. And so I would discover at 5 or 5:15, the office cleared out, and I'd be there by myself till 7, because I couldn't understand how people were able to do any work. I mean, you spend a lot of time going to court, and when you're going to do your writing, when you're going to do your research, you're going to have to do it after work. And this is also before the days when you could work from home, you could get on a computer network, so the typewriters were there, the papers were there, the files were there. If you're going to work, you really had to work in the office.
Right.
And so that was, and that actually, I sort of went through the same process, which was, it was really fun, I really liked it, and then little by little, I sort of started to get tired of it.
Why do you think, just jumping back for a sec, why do you think the culture was different in Waterbury?
I don't know. I think it may have been. I think New Haven may, and it may still be, but certainly then was a very special program.
Okay.
I mean, it really. I mean, there was a level of skill and commitment. This is not in any way to denigrate the people who were working for any other program, but I think there was something special about it. And it was an early program. I don't know. I really don't know. But it was. I mean, there were ways in which it felt different, and I had plenty of interesting experiences in Waterbury. One of the things that proved to be very important for me, and this is something I wouldn't have predicted or wouldn't have known, was that I was starting the days before specialization. I mean, right now, the strong tendency is for legal services people to find sort of one subject matter niche, or maybe the program is to require that they find one. And then you're put into that, or maybe even hired. They need a family lawyer, so they hire a family lawyer. You're not going to do some family and some housing and some benefits programs. They're really going to specialize you. And the programs have dealt with sort of how to keep people from being totally locked into nothing but one subspecialty. But basically people specialized then. Excuse me, then you didn't. We had in Waterbury, you had, I don't know if it was like one day a week, you were the intake lawyer. And you took whatever walked in the door that day. And the result was I had some of everything. I mean, I had divorces, I had a bunch of eviction-related cases. I had even had some tort defenses. I had small claims. I had welfare fair hearings. I had a half a dozen Social Security disability cases, which were great, including the one where I got to write a letter after the guy died saying, "I told you he was disabled." And you wouldn't. He told us that he was disabled, and nobody would believe him.
Was that your favorite type of case?
Well, I like the Social Security disability. I had some really bizarre clients, but and actually, that was the only case I lost.
Really?
It was the one which the guy was so sick he died, and they said he wasn't disabled. Because you tend the way, and again, things may have changed, and I haven't done Social Security for decades, but there at the initial level, the initial review level, the Social Security Administration just loved to say no, but when you got up to the level of a hearing officer, they were very receptive to sort of. They didn't mind overturning.
Right.
And so if you put together a decent case, you pulled in the medical evidence, which typically the applicant wasn't able to do when he initially applied, you had a pretty good chance of winning an appeal. So it's probably not unusual that there's a good winning percentage. So as it turns out, the generalization helped me later on when I ended up in the legislative office.
Right.
Because I knew a little bit about everything. To the extent I was specializing, it tended to be in housing, and which translated really to eviction defense. So I probably did more of that than anything else. And I particularly liked that because I liked the procedural aspects of it. And Frank Deneen was like the expert.
So you learned a lot from him.
Yeah, in Connecticut. Well, he was the expert on procedural defenses. And Frank, through his own litigation, had sort of started the process, which subsequently became very well established, that because the summary process is a statutory remedy, it is that you strictly construe it because it is not it takes you away from the common law, so you have to follow the statute strictly, which then leads to the argument that if you do not, in an eviction case, cross every T, dot every I, then you don't get the benefit of summary process, you can't win the case. And so the notion that what a lawyer does is he looks very carefully and parses everything and looks at every detail was something that I think Frank really taught. And that's, I think, is sort of essential to good lawyering. The lawyers who don't look at the details are likely to screw up their cases, as well as miss defenses. I have a feeling that's what happened like in the Skakel case.
Okay.
Something tells me Mickey Sherman didn't pay attention to details, but I only know that from the newspapers,
Right.
not from any other knowledge. In any event, so I was in Waterbury from the fall of 1973 until the fall of 1976. So I always said 2.5 years. That seems to be too. Maybe I've extended. Because that was more or less what the case was.
Okay.
So what can I tell you?
So what did you do after Waterbury?
Well, before I had some. Let me take Waterbury because I had. I mean, there's some interest. There were lots of interesting experiences while I was there. One very important judge was a Superior Court judge based in Waterbury, actually in Litchfield and Waterbury, but it's John Speziale. He went on to become Chief Justice of the Supreme Court. And I had just started legal practice when the legislature had passed no-fault divorce. And I learned something about the judges there that I don't know that other people know, which was and this was hard. It seemed like no-fault divorce is common sense. But at the time, we're a very Catholic state, and there were a lot of people who did not believe in no-fault divorce. I mean, they really believed that you had to have fault. The marriage was sacred, and you couldn't just end it because you felt like it. And the law said, they even changed the name. It became dissolution of marriage instead of divorce. I was representing somebody, and you for the uncontested divorces, you would go through this little routine where you ask them who they are and how many kids you have, and basic questions like that to be on the record. And then with the new no fault, you would ask them whether they believed that there was any possibility of reconciliation, because you sort of had to prove that the marriage had broken down irretrievably. And in this one case, I asked, it's like, you won't have 4 kids, and I said, and how many children you have? 4 children, and how many years should of the marriage? And she said 2. And then, so and the complaint identifies the date of birth, but all 4 kids showed dates of birth after the date of the marriage. And Speciale, who's on the bench, says, "Counsel, I want to see you in my chambers." And we go into his chambers, and he says, "I don't care what the law is. I cannot give a divorce to a woman who's had 2 children with another man while she's married. You have a choice. I will either deny the divorce, or if you want, I will give you a continuance. You can wait until another judge comes in."
Oh.
So we continued it.
Mm-hmm.
And to me at the time, he was just another Superior Court judge. There were Superior Court judges who were really hostile to legal services, but he was actually a very good judge, and he went on to this whole career. And I sort of feel, hey, I know this little piece about him from the early years. The first 2 cases I had, the first 2 housing cases I had, also taught me something about the status of legal services in those days, and actually the status of the law, because judges are much more professional now than they were 40 years ago. I'm trying to remember, I don't know the sequence of which case came first, but one was the first trial, the other I think was the first motion hearing I had. On the motion hearing, I filed a motion to dismiss, because that's what they teach you to do. You look for a jurisdictional defect, you file a motion to dismiss, because there's something wrong with the notice to quit. And I go into court on the cat's calendar, and they call it. Now it's my motion, right? And I don't even remember who the judge was. And I don't remember who the other lawyer was. But they call the case. The other lawyer immediately gets up and says, "Your Honor, this is another one of these dilatory legal services motions. All it's designed to do is keep this case from being heard. The tenant hasn't paid any rent." And, we had other potential defenses coming. And it just went on, and the judge says, "Motion denied." And I said, "Your Honor, it's my motion. Don't I get to speak?" He said, "I've already decided this matter, counsel."
Wow.
I guess that was one thing. Second thing was, there was a guy named, I can't remember his first name, it was Judge Wall. And there'd be a family calendar, so he'd be handling the divorces. And they would, and it would typically be a long calendar, so it starts at, I don't know, 9:30 or 10 in the morning, and would run pretty much all day. And they would, and the calendar would have the cases in sequence. And so, you always you'd like to hope your case would be near the beginning instead of near the end, because you really had to hang around. So they got your case. And Wall, and you have to be, you really can't go away. I mean, it's just too risky. And they called the calendar, and Wall said, essentially, I'm going to take all the cases first of the private attorneys, and then, because they have work to do and have to get back to their offices, and when that's over, then we'll pick up the legal services cases. Huh? So that was sort of
why do you think that was? Why do you think judges and private attorneys were so hostile to legal aid attorneys at the time? And how and why has it changed?
Well, they were hostile because people used to making cases. Everybody wants to make cases as easy as possible. In most cases, if the defendant, the other side, had no lawyer, they would typically either default or they would kind of be at your mercy. You might meet with them in the hallway and simply tell them what you were going to do, and tell them that if they don't agree to it, it'll be worse. And so you'd walk in with agreements that they really had no understanding what they were agreeing to. Or even if you went all the way to the point of a trial, there was a sense that pro se litigants really didn't know what they were talking about. Lawyers did. The lawyers who brought cases were regulars in front of the court, so the judge would get to know them. There was really, I mean, it's not all judges were like this, but there was really a general sense that you looked to the bar. And then these legal services guys came in, and we didn't want to settle every case, or we were filing defenses in eviction cases. And if we thought we had winning cases, we might leverage decent compromises, or we would insist on a trial. And then in some cases, we actually had the call to appeal. And so, by and large, people didn't like us because we were
Making their job harder.
we're making their job harder and taking a somewhat different approach and doing it for clients who in the past they just had rolled right over. And so I think that was a significant part of it. And I think over time people's attitudes changed. I mean, legal services became more accepted, more respectable. I mean, I'll tell you one thing I remember was when, and again, I'm going to get my years mixed up on this, but I think this was the first year. The Waterbury Bar Association had a Christmas party every year, and like the legal aid people, we didn't feel very connected to the Waterbury Bar Association. They were like our enemies, and so something that we didn't pay attention to, and it was either the first or the second Christmas that I was there, I kind of arm twisted people to go to the Bar Association's Christmas dinner or something, and it's not that it made any difference, but that I think some of that notion that we as legal aid people were part of the local bar, that we ought to read the local newspaper because we ought to know what's going on in the town. I think in the early years we may not have felt that. We sort of felt more like we were isolated, and maybe we still do to a significant extent. We don't. I mean, I lived in Hartford at the time I was going to Waterbury, so I was, a commuter from somewhere else. And there were people in the office who did work who did live in Waterbury. But I think, I don't, and this may still be true, I don't know to what extent, it's prized within legal services that you make yourself, regardless of where you live, you make yourself part of the community. And I think some of the lawyers do it naturally, because that's what they want to do. Some really prefer to be, to commute to their job, and there's nothing wrong with that. I mean, and some of our best lawyers, you don't have to live in a community to be a good lawyer and to really do a good job for your clients. But it sort of made it, for me, it made a kind of a difference in feeling about the place. And so I got to like Waterbury. I mean, it's sort of a strange place, but I got to like it. So anyway, the other eviction, I'll tell you the other story. And the judge was Chernoskas, I believe was the judge's name. I mean, these people, I think, they're all dead now. But it was a single family house in, I think it was Middlebury. It was like a suburban town. It wasn't in the city, and it was a big family, which is why they were in a single family house. They were very poor. And in those days, when I got a client, the first year or two, I always went out to the property in an eviction. Now, nobody's going to do that anymore, I don't think. But, I had a little different attitude about that stuff then. And so the house was a disastrous mess. And it wasn't their fault. It was like the roof leaked, the basement had water in it. I was pretty naive. I had not seen such a bad place that people actually lived in. So of course we're going to raise a habitability defense. Right. And I thought I had a great idea. I filed a motion to have the judge come and do an on-site visit, and he granted the motion. So it was like my motion, and I thought, well, this is great. The judge is going to see what this place looks like. We can't lose. So he comes out and he walks around. He goes through the house and then we go back and complete the trial. And then I get a decision on one of those little postcards, the old 3x5 postcards. So it's typed, it's no margins. And the decision basically says the court has gone out to the property, has inspected the property, has looked at the yard, has looked at the inside, it's looked at the basement, it's looked at every floor, it's looked at this, it's looked at that. Judgment for the plaintiff.
Nothing else.
Nothing else. No legal explanation, no reasoning, no relating what he had apparently observed to any particular defense we'd made. And this is where housing law was in, say, 1974, 1975. And that was the fact that we didn't just get a notice saying judgment for the plaintiff, but actually something that said something, but it didn't say anything that was of any useful information. Anyway, so
interesting.
So that was Waterbury. So then, and then But again, it's sort of, I can see now that I think about it, a little repeating pattern here, because I was very stressed. This is why I say I could never have been a criminal defense lawyer, because as I took on more housing cases, I began to feel really stressed about those cases, because if I lost the case, they were out on the street. So it became really important not to lose the case.
Mm-hmm.
And if I was able to bargain something easily, I always thought I hadn't asked for enough.
Mm-hmm.
Because if if I offered a deal and they took it, I said, wait, I mean, I should have asked for a better deal.
Right.
So with time I started to feel bad that I wasn't doing a good enough job. And I actually took my only really long vacation I've ever taken in my life. I went to Europe for 5 weeks.
Wow.
In the summer of, it's gotta be summer, I can't get these years straight. 76, 75.
After
73.
Waterbury?
That had to be the summer of 75, so I'm not, 73, maybe I only worked for 2 years. I can't quite get these numbers right. In any event, I came back and it was like, I have to do something different. And something had happened during 1975 that proved a big game changer for me. And that is, I was living in Hartford, I was commuting to Waterbury, and in 1974, in the fall elections, a guy had been elected to the Connecticut General Assembly from Rocky Hill. He was a lawyer. His name was Richard Tolosano. He was sort of a moderate Democrat, but he had an interest in landlord-tenant law. I think he had clients in his private practice on both sides of the issue. And so he was a freshman legislator in 1975. And he decided that Connecticut needed a more rational set of eviction laws and housing laws in general. And he hooked onto the Residential Uniform Landlord-Tenant Act, and he proposed that as a bill. And his belief about how you get legislation passed is you bring the stakeholders in, and you throw them in a room together, and you make them work out a compromise. It's exactly the right way to do legislation. And he needed a couple landlord lawyers and a couple tenant lawyers, and he contacted Neighborhood Legal Services in Hartford, and I knew somebody. Actually, it was my girlfriend worked with somebody's wife. I mean, it was these connections, who knew that I was doing housing law. I was in Waterbury, but I lived in Hartford, and of course, capital's in Hartford. Sorry about that. And so I was volunteered, willingly, that I was volunteered to be, it turned out to be the legal services representative to these negotiations. And so like once a week he was having people come up and meet. And we went through, it was a complicated bill, it was like a 30-section bill.
Wow.
And we went through it line by line, exactly what I've been trained by Frank to do, is
Right.
parse every single word, every single comma. And what we ended up doing was, so I was commuting basically because I was working in Waterbury, and at the end of that legislative session, he had a bill, that Tolosano did, and it got backed up in the rush of business at the end of the session, and it died on the calendar. So there was sort of a compromise worked out, so what he did was he pulled people back together between sessions. In 1976, he was ready to go. But because I've been doing this legislative work, I really started to get interested in that. And legal services programs at that point were doing their legislative advocacy from New Haven. There was New Haven Legal Assistance had an office called the Technical Assistance Project, of which Ed Madison was the director. And when they needed somebody to go up and do legislative advocacy, they would work typically through that office. And they kind of recognized that it was inconvenient not to have a Hartford office to be doing legislative advocacy. And so what they did was by 1975, they were talking about creating a legislative advocacy office in Hartford. And so I was interested. I thought that'd be great. I wouldn't have to commute to Waterbury, and I was sort of really gotten interested in legislative policy. But they weren't ready to hire. And they had sort of their own plan for doing it, and I, on the other hand, was ready to quit. And so I actually ended up giving notice, and I believe I officially quit like at the end of the calendar year, and they still were not ready to start the office. They essentially told me that they wanted somebody with real legislative experience to head it, and I would be sort of like a great second staff person.
Mm-hmm.
Structurally, they made it part of the technical assistance project. So it was part of New Haven Legal Assistance. The real office was in New Haven, but there was going to be this sort of outpost satellite office in Hartford.
Right.
And then in February of 1976, the legislature went into session, and they still had not hired, they hadn't found the experienced person they wanted. And I got a call like the day and night before saying, we got to start this office. Will you take the job? So at that point, I'd been out of work for a month and a half. And I took it. So I started like with nothing. I mean, I was like, you start the next day.
Wow.
And that was a really remarkable session because it was not nearly as much fun now as it was then, because I really didn't know much about lobbying. I mean, I knew about issues, but I didn't really understand the process. And it turns out in Connecticut, anybody could have incredible influence on legislation. I mean, it's just remarkable. It's not like Congress. You know, your picture when you go through law school, and to the extent you learn about legislative matters, you learn about it in the U.S. Congress. You don't learn about it in state legislatures. And in Congress, it's just, it's a huge, bureaucratic, heavily staffed entity. And to make anything at all happen requires a long time, requires tremendous amounts of conflict. Everything's backed by loads of staff work. Connecticut has a part-time legislature. It meets alternate years, 5 months and then 3 months, 5 months and 3 months. It's really a citizen legislature in the sense that most people have other jobs because they pay more now, but then they paid so little that you really couldn't support yourself. So you needed to have like a spouse who had a real job, or you would have independent wealth, or you had to be prepared to live on next to nothing. And so that they needed information. What they lacked, and they were staff, but they lacked people who could tell them what these things were really about. And the public hearing structure was such that anybody, and this is still true, anybody who wants to testify at a public hearing can testify. They do go sign up on the day of the hearing. They'll keep the hearing open until everybody who shows up has testified. And if 100 people show up, it'll go until 100 people have testified. And so it's very open in that sense. And legislators feel pretty responsible to local constituencies. So in any event, so two things happened that year that really made an impression on me and really kind of kept me doing this ever since. One was that Tulsano finished the process. So he brought the bill back. There were some adjustments made at the last second. There was a drafting screw-up that required the bill to be amended, which turned out to be great for us because it clarified an ambiguity about whether rumors were regulated by this act or not. The answer is yes, and we know it for sure because the staff at the legislature misdrafted the bill, and Tulsano had to offer an amendment on the floor to fix it. That was what the fix was, and he had to explain the amendments, and all of a sudden there's legislative history. He had so succeeded in bringing the two sides together that when I was sitting in the gallery when they did this. They called the bill. It was very early in the session. The bill was 27, 30 sections. And Tulsano does this little 2-minute introductory speech about what this is all about. And then he says, let me go through the bill section by section. And people the legislators start shouting, vote, vote, vote.
Wow.
So he just stopped and called the vote, and the vote was like, I don't know, 141-3 or something. And so there's very little legislative history, other than the history of the rumors on the amendment, on the floor of the House, when you look at the transcript. But it was really a credit to somebody who got everybody so much on board that nobody wanted to spend the time arguing about it because nobody's against the bill.
Yeah, there's one little one.
And so that was one lesson. And Tulsano went on to become one of the most important legislators over the next 20 years. And using that method of paying attention to details, bringing the sides together, looking for middle ground. Connecticut has one of the, I don't know, maybe the only, I don't know, but it's one of the few places that codified Roe v. Wade. So we have a statute that is Roe v. Wade, basically. And he got that through, this is well into his legal career, he got that through with a nearly unanimous vote. And when you realize that you've got pro-choice people and anti-choice people, and he managed to sell that as a compromise. He managed to sell stuff on gay rights as a compromise. And he's a moderate Democrat. He was not, but he was a civil libertarian. And so it was a very interesting combination. He died a few years ago, but I mean, he was just, anyway. The other thing that happened was, as when you lobby, you need to, there's a system by which you can look at every bill that comes out. But you need to monitor them. And so this is my first year doing this. I started doing it. I was very interested in consumer law. And a legislator put in a bill to deal with a problem with repossessions of cars. You had a car, it would get repossessed, they would take it and they would sell it off at like at a dealer's auction for $50 or $100, and then they'd sue you for the deficiency. So you would end up with, you bought a car for $2,000, you'd end up with your car repossessed, so no car, and you'd still owe $2,000 because they give you the credit for what they got at the sale minus the cost of the sale. It was like zero. And somebody at UConn Law School had done an empirical study in which a few years before, published it in the UConn Law Journal, in which they compared the price, they did case by case, the price that was obtained at the dealer, at this wholesale auction, with the price that car was subsequently sold for, and then compared the numbers with the Blue Book. And they discovered that if you credited the retail price instead of this off-market wholesale price, basically you'd never owe a deficiency on the car, almost never owe a deficiency on the car, unless the car was really defective. And the proposal that I had seen from a legislator, which was a simple proposal, that said we would prohibit these dealer auctions on repossession from being by private sale. They would have to be by public auction. Mm-hmm. Well, first of all, they really were by public auction. But second of all, the problem was public auction. That wouldn't solve it. And so I went to the legislator, who was a new legislator, and sort of said, you have the wrong solution. You have the right problem, wrong solution. He was really interested. He was young. He was aggressive. He picked it up. We wrote a bill that was an election of remedies bill. In other words, you can either repossess the car, you can either sue the person for what he owes on the debt and collect it by the normal means of suit, or you can repossess the car and he doesn't owe anything. Choose. Choose your remedy. You can't have both. And he pushed that very hard. The banks hated it. And we got like a 90% compromise through. And we probably have one of the best repossession laws in the country as a result. It's 100% election of remedies essentially for everything except cars. And for cars, there's a rebuttable presumption that every car that's repossessed is worth its retail book value. Huh. But it can be rebutted. The compromise was we had to give in on the rebuttableness, so it wasn't perfect. But for like sofa, furniture, electronics, they repossess those. You don't own them. I mean, if they want their money, they have to let you keep your electronics and sue you. So, unless they can take the security interest, then that's different. But anyway, so this is maybe telling you. We're slowing down too much here. I'm sorry. You should push
give us the details.
You should push me forward if you want me to move on. But the result was. I mean, who am I? I'm one guy. First year lobbyist, and they've just changed the repossession law, and they wouldn't have done it if I wasn't there. So you come away thinking, and then this was the other thing. The clients we had who had had their cars repossessed could not in any way be helped by this. Right. But everybody else would be helped. And nobody would have to litigate. And so kind of part of that lesson was that legislative work was very much like class action work. Because you were affecting, in one case, you were affecting large numbers of people. And so the level of relief that you got if you were successful was huge. Even though your particular client or the person who had been your client, it really only served as an example of the problem. You couldn't fix it for them retroactively. And that sort of, it helped me understand the importance of the legislative process. And in the first half dozen years or so that I was lobbying, it was like a time of sort of liberal politics. And so there were all sorts of things we could get, programs we could advocate for. Legislatively you could ask them to raise welfare benefits. You couldn't, there's no way to do that through litigation. there was, I mean, the way we divided up my office, sort of the way it turned out, because from the beginning we had 2 people, and then at times it grew a little bit. But I was always, at the very least, doing housing law, consumer law, and family law. So those were sort of my primary areas.
And how did you know specifically what types of things you were going to work on
What I would
at
do,
one time?
what I would do is, so I mean, the office I was in didn't see clients. So what we did was we initially we sort of organized this. It's now become sort of standard practice, especially with Connecticut Legal Services, to have, probably with everybody, to have meetings, in-house meetings of people who are specializing in the same area. So like the housing lawyers might get together. But I needed all the programs. I mean, I was working for all of them, not just for one. And even though at the beginning I was working for New Haven Legal Assistance, but everyone perceived the job as covering all the programs. So what I would do is either I would create sort of my own working group by subject matter of legal services lawyers, or I would hook on to, more likely I would hook on to the existing group, but make sure it was an inter-program group, and then sometimes add people who kind of we shared, our close legislative allies. So for example, with housing, we invited the Connecticut Housing Coalition to send people to those meetings, because we worked together on basically on all issues. So I would be meeting primarily with my constituency, my immediate constituency, were legal services lawyers. And that's who I would meet with, and they would bring sort of the cases. And then from that, we would sort of figure out what legislation we needed. If we needed to generate legislation, they would be my consultants. If I was monitoring legislation from other people and I needed advice, I would sometimes try and get them to come to be witnesses at public hearings, though I did a lot of my own testimony, because in some ways it was easier to do it myself. It was time consuming, but it was easier than trying to manage other people doing. And also a lot of the legislative timeline is very, very short. I mean, so for example, under the current rules, which have been around for quite a while, if a committee, you have to hold a public hearing on every bill, and you have to give 5 days notice. However, you don't count either the first or the last day. And you do count weekend days. So for example, if they're going to hold a hearing on a Monday, they can give the notice on Thursday in the bulletin. But you might not see the bulletin at 9 o'clock on Thursday morning. You might not see it till 3 or 4 o'clock.
Right.
I mean, now at least the bulletin's online. So you could see it from home the night before or something like that. But then you had to physically pick it up at the Capitol. So you're finding out something at 4 o'clock on a Thursday for something Monday, or Friday would have to be by Tuesday, because Friday, Saturday, Sunday, Monday, Tuesday. So the hearing is going to start at 9:30 on Tuesday morning. You've got to get your notice out Friday and line up your witnesses if you're going to do that. So I mean, it's compared with most other lobbyists, I do a lot more actual public hearing testifying. They typically, the contract lobbyists typically bring in, I mean, many of them don't testify at all.
And so what's that like? Do you enjoy testifying?
Yeah, it's fun. It's fun because I'm not, I have some of the right skills for the job, but I lack some of the key skills. And so part of what I've had to do is make up for what I lack. So I'm not a schmoozer. And I don't have any state anything. I don't know about I don't ask about people's kids, because I know I won't remember 5 minutes later. And I don't do that kind of approach because I can't. I'm just not good at it. On the other hand, I can write, I can argue, I can organize. I mean, I have sort of a lawyer's mind.
Mm-hmm.
And one of the ways that plays out is the contract lobbyists during legislative session basically live at the state capitol. I mean, they're there from morning till the end of the day. And the way you catch people, if you want to talk to them, is you catch them. Making appointments is very difficult. You make an appointment if you have a client you want to bring up, and then you make an appointment because you don't want to bring them up and the legislator's not available. But for the lobbyists themselves, most of you try to make an appointment, they'll give you an appointment, 5 weeks into the future. It's not really timely.
Yeah.
So you catch people in the hallways, which means you hang around, you chit-chat with people, you sort of make friends, and you catch legislators when they go by. I'm not good at that. The public hearing gives me an opportunity to talk to multiple legislators about the issue simultaneously. So it's otherwise, so if there, now lots of times there are not many committee people there, but if there are 6 of them there, that's 6 people that I'm talking to at once. Usually the key people on a committee are there, at least one, maybe both of the co-chairs, the ranking members. And you have an opportunity, my hope always is at a public hearing is they'll ask you questions. Because all the committees now use the structure of you get 3 minutes. And it's because they put many, many bills on the agenda for every hearing. You don't get 3 minutes per bill. You get 3 minutes, period. So, I mean, there have been hearings where I've testified on 15 bills and I have 3 minutes. And you can't say much about anything unless they ask you questions. So you always hope for questions. And the questions also allow you to engage. I mean, you find out if people disagree with you, why they disagree, so you can try and respond. So, I mean, so hearings like it's like arguing a brief on appeal. And, and a lot of people, I think, say if you're doing you're arguing an appellate case, they want the judges to interrupt you and ask you questions, because that's rather than just you give a speech and you sit down and there are no questions, because you'd like to know what they're thinking and you'd like to disabuse them of things that they're thinking incorrectly. And it makes a difference. And that's my experience has been it makes a difference. And sometimes it may lead to a compromise that that they say, well, why can't you do it this way? And you start thinking, well, yeah, I guess I could. And I mean, so it's an important part of the process. In any event, so that's, I mean, the first bunch of years, we were really the initiator of a lot of proposals, and there was a sense that you really work at it, you can push things through. Always that sense of amazement that stuff did go through. As time went on, the politics started to turn more conservative, and we ended up, for the last 15 years or more, it's been largely defensive. I mean, the gains that we made in sort of the 1980s, they want to take back. They want to undo these things. So, I feel like I've become Mr. Conservative.
Really?
It works, it's fine, leave it alone. Don't change it. And somebody's got this problem with it, well, it's not actually a problem with the statute. It's somebody's not using the statute properly. I mean, and it's true, because certainly in the case of eviction law, I've had to totally approach it in a different way than I did initially. When we almost got just cause eviction through Connecticut, and I think it was 1983. We lost it on a tie vote in the House of Representatives because we stupidly didn't take a compromise that would have gotten us one more vote, because we didn't know it was going to be a tie vote. And the compromise would have been a delayed effective date. One person, so this is a close vote. One person says, when I'm lobbying them, that he wants there to be time for people to adjust. Just cause eviction is simply that you can't evict people for lapse of time. You have to have a reason. You have to cite. You said people always do have a reason. You have to disclose the reason and make that the ground for the eviction. From a landlord, lapse of time is perfect because you don't have to prove anything other than the lease lapse. New Jersey has that statute. New Hampshire, I think, has something sort of like it. Now, his hesitation made no sense, because this is not something like healthcare where you have to sort of redo a system and you need lead time in order to do it. He just wanted to say, I'll vote for it, but I'll only vote for it if nobody in my district is going to be affected by it for another year. And so we said no, we wouldn't take the compromise. And it turned out he voted no, and his was the deciding vote.
Wow.
And then the politics changed, and we could never get that bill back to the floor again. Because by 1984, people were thinking more conservatively. So it's the kind of thing, it was a moment in time you could have passed it. We blew the moment, and then we couldn't do it the next after that. And through the 80s, there was that process in the 80s as the politics was becoming more conservative. So by the time you got to the 1992 or 93, it was becoming sort of totally defensive. We were still getting stuff through up into the early 90s. And so that sort of changed how this affects me, because it means I'm not looking to bring in new things as a general rule. I mean, I have I've got all this stuff on my computer. I mean, I write testimony by going to the computer and pulling my stuff up from last year, the year before that, and editing a little bit, because there's so many of the same things that we're against every year. Don't change this, don't change that. So that sort of, you can't help but become a little bit less enthusiastic when that's going on.
Right.
But it's still an interesting place. I mean, and I've gotten to do, personally in terms of what I do myself, there are other things that, it's led to my doing other things as well. That,
like what?
well, this is in hiatus now, it's been in hiatus for a while, but in the early 80s, I created something that we call the Legal Services Housing Index, which started very small. It was just taking all the housing cases, starting with housing court cases and appeals, and indexing them by subject matter, and then figuring out different ways to index. I mean, I like to, librarian thing,
Right.
make a bunch of cards, stack them, and then restack them using some different, factors for stacking. And it really proved helpful for the lawyers writing briefs. And then we ended up selling it to the private bar. About half a dozen years ago, we tried to convert it to an electronic document instead of a hard copy document, and we still have not completed the process. And then I got out of the habit of doing it. And so once you get, it's like you make time for stuff. You don't keep, you make time for stuff because you have to. You stop, and then your time fills in, and so it becomes very hard to pick it up again. But I did that. As part of legislative stuff, I would end up on various advisory boards. I'm now the chairperson of something, well, they just changed the name, but it was called the Citizens Advisory Council for Housing Matters, which actually was the way we got our housing court system. Richard Tolosano, back in 1976, in addition to this Uniform Landlord-Tenant Act, which is not uniform in Connecticut because we changed it so much, but in addition to that, he wanted to see a housing court system. And he was thinking about New York had housing courts, Massachusetts had housing courts, and we just ran this through the regular court system. And so he ended up trying to get one started. They ended up with a study commission to study housing court. They needed a tenant person. This was the first year that I was lobbying. And so I was put on as the tenant person. And then we spent, and actually we were against the housing court because we were afraid it was going to accelerate evictions. In fact, we were totally wrong. I mean, it was pushed by a social service provider in Hartford, a woman named Pat Auger, who worked with tenants and really passionately believed in this. We ended up recommending a pilot in Hartford, which was started at the beginning of 1979. We put into our bill a requirement that there be an advisory board, because there were informal advisory boards in Massachusetts. And so we made it a statutory advisory board, which I was appointed to in 1978. I'm still on it. And I've been chairperson of it for a number of years because the governors have not bothered to appoint new people, and they drop off through attrition. But that was important. It was important because it gave us a role. I mean, it was a very diverse board. There were landlord people and tenant people, but it was a role in sort of influencing how the housing courts administratively work. Not influencing the decisions, but influencing sort of the structure, how accessible they were for pro ses. So, for example, I got very involved in creating pro se forms, and we worked with the housing court staff, and they really did the real work. And so the housing court in the 1980s was using typewritten pro se answer forms for litigants well before the judicial branch decided it made sense to become more user-friendly to pro ses. And I mean, and there's always this tension with the main judicial office because these were unauthorized, unofficial forms. And there was always the fear that judicial was going to say you can't give those forms out. But it created within that court a sort of a tradition of pro se receptiveness, notwithstanding the fact that summary process law is very technical. And I mean, there were a lot of good things that came out of that, but it's I was on the Law Revision Commission has advisory committees on various subjects, and I would get appointed to some of those because there was a lot of consumer stuff, and I'd be a consumer representative. It was like doing a lot of those things, and much less now. I'm on one task force right now on anti-blight legislation. But so it's, and I get to see all the legal. I mean, I get to see in my areas at least. I see all the legal services lawyers, and so it's you built up a working relationship with people. So
how's this funded? I'm just curious.
Well, I don't actually know all the details of funding, but basically the 3 intake programs, not statewide. Statewide is under a whole bunch of restrictions, and
Right.
and they do not fund legislation. But the 3 other programs, which are the intake programs for clients, function as our board of directors. Their executive directors are our board, and they share the cost of running our office, and then I think my executive director does fundraising as well. We're a 501c4, we're in the C3, so we're not restricted on how much lobbying we can do. So for us, that's not a problem. But we do I mean, I think we exist for the lobbying, but we do a lot more stuff. Lobbying, I think, is well less than 50% of what we do. I don't know the exact numbers, but we do the pro se pamphlets for the legal services programs. We used to do a lot of training. We do much less of that now because there used to be money for training, like training of legal services staff. So we do those kind of things here, and so we're a part. We are. I mean, there are basically 5 legal services programs in Connecticut. The 3 intake programs, the statewide hotline, which is statewide legal services, and our office. And we're all kind of interrelated in various ways. They're all separate corporations. And we were spun off from the Haven.
And how many employees do you have here now?
6, 7.
Okay, so it's...
Maybe 7, maybe 6. Well, then we have to cut the offices.
So have you seen has there been times where there's been a lack of funding and you've really felt the lack of funding and what you've been able to do in terms of
yeah, I mean the major. I mean, we sort of go up and down as the programs go up and down.
Right.
So when funding issues have seriously arisen, and programs cut back, there can be cutbacks here as well. I think the programs view particularly the legislative advocacy function as a very important function, and there are 3 of us who do that. But I'm 80%. I'm not actually 100% time. Sarah Parker McKernan is 80%, and Jane's 100%. So even at the lobbyist level, we've cut back and have not gone back to the full 100%. And that was basically cost driven. At one point we were down 1 staff member. Well, actually, maybe we are still at this point. But we haven't. I don't think we didn't have the kind of. I don't think we've had the kind of large layoff that when IALTA sort of collapsed, some of the programs had to do. I mean, the programs had to make very difficult decisions about either laying off staff or going and putting people on furlough or doing something else to effectively cut people's salaries. And each of the programs did it their own way. Some of them are union. Some of the programs are unionized, so that's going to have to be negotiated. We basically laid off a person and cut people down to sort of high part-time, not
right.
to like 4/5 time. Some people, not everybody. And then we got the legislature provided some funding. Twice in the recent years has provided structures for ongoing funding for the legal services programs, which doesn't come to us directly. That goes to the intake programs, but it makes it easier for them to maintain funding for us.
Okay, interesting. I just have one more question. So What's been the impact on your legal career? I mean, you've been here for a long time now. How come you have decided to stay and to continue doing this legislative work for legal services? I mean, clearly you enjoy it, and so just, I guess, provide us with a brief summary of why you continue to work here.
I mean, well, inertia. It's partly it's what I've gotten used to doing, and I'm not particularly looking to find something different to do. I have no desire to retire. I mean, I'm now at a point where you see various people who came into legal services roughly when I did, and they're at that point where they're opting for retirement. I mean, there may be a point where I will feel I really can't do the job well enough and I need to retire. I haven't hit that point yet, and it gives it. I mean, this particular job, and one of the things that has kept me in it, from a personal kind of rewards perspective, is that it gives me a tremendous amount of time flexibility. I mean, it's very seasonal. It has a very busy season when the legislature's in session, and then it has, a slower season, and the legislature is in session. Given the 2-year cycle, it's in session 8 out of 24 months. So there's flexibility. I mean, in earlier parts of my job, that's what gave me the freedom to create other things. Like the housing index was a product of knowing there was something that was needed and figuring out, gee, I could off-session work on it. So it made that possible. And that's still true. Now that we've got we've got computers and networking, I can do work at home if I want to. I'm a night person. I'm a total night person, and so I've been that, since I was in high school, and college. Always wrote papers. Start at 8 p.m., 8 at night, and try and get finished by 6 or 7 in the morning.
Oh wow.
It's just the way I function, and so one of the advantages of having time flexibility is that I can do that if I want, so I can shift hours around to the time that works for me. If I would need to free up some time during the day to do other things, it's much easier to do because I can work in late in the evenings and make up for that time. So there's some personal things about the job. There's, nobody's essential, but there's a sense in which I worry. How we probably need sort of a succession structure that we don't have, is to make sure that we don't go any more backwards than we've had to go. I don't know. So I enjoy it still, but I have a lot of mixed feelings about it.
Mm-hmm.
And I don't know what I don't know what I would do if I'm retired. I would think I would go nuts.
Mm-hmm.
So it's and people do find other things to do. I mean, everybody worries about that, and everybody finds other things to do. But this, it's and I've now kind of gotten to the point of being. I mean, I'm one of the longest duration lobbyists there at this point. Not the longest, but one of. And there is a certain amount of people know who you are. And it's kind of, personally that feels nice.
Mm-hmm.
But I also recognize that if you don't, you lose, the personnel changes. When you're practicing in court, the change of judicial personnel isn't that big a deal because, first of all, the judges are always rotating around anyway, so you don't get the same judge forever. And there've always been significant differences between individual judges, so that's not really different. You learn who the new judges are. The legislature, you've got long-term people who you get to know, and you have new people coming in all the time, and older people going out at the end, and not older not by age, but the people who go out sometimes are long-term people, but often they're short-term people. So sometimes they're people in there for 2 or 4 years. And then they're gone, and I've never even met them. But little by little, as the long-term people leave, some of the people that I've had those connections with aren't there anymore, and you kind of have to prove yourself all the time. But as time has gone on, I'm up there less. I mean, we now, in various ways, we somewhere along the line, we started hiring a contract lobbyist to supplement what we do. That's Betty Gallo and Associates. And initially, she was really working with Sarah and Jane on their subject areas. And then in more recent years, we've started to hire her to cover some parts of my subject areas. So before, I still had to do everything myself. Now, some of what I used to do, somebody else can do for me, which is great. But it also has the downside that I'm not seeing legislators as frequently. You see them less frequently, they don't know who you are, and they care, you know, they're going to be less responsive to you because you start to be a stranger. So that's sort of, it's part of the process, and so I can see that aspect of it. So balancing all those things is something you have to do. But no, I don't know. I mean, you know, the subject matter is important. Anybody who's in legal services, it seems to me, unless they're in and out within a year or two, is there because they believe in the system that provides representation and justice for low-income people. And I mean, I haven't talked about that in this interview, but that's really, I mean, I really believe for everybody who stays, that's ultimately what keeps them, that you're doing something that needs to be done and that is really important and protects the interests of a lot of people.
So that's one reason why you've stayed?
Oh yeah, yeah, of course. I mean, for sometimes, you know, sometimes you get, there's some portion of new lawyers that comes in because they want to get some experience, then move on to something else, and they may move on to something in you know, conventional private law practice. They may move into a public defender's or attorney general's position. I mean, everybody's different, but sort of the people who are here long term are all, I think, really committed to why the legal services programs exist in the first place. So in talking to you, I'm sort of taking for granted that, I mean, that I don't even articulate it because, yeah. You know, to me it's really very evident. So it's important, and you know, law makes a difference. It really makes a difference, and that's part of. I sort of knew it in theory when I was in law school, but I didn't really gather it in practice until I started the law school clinic work, and then the legal aid work, and then you see how things make a difference. One of the things that I discovered once, I did this I don't even know why I did this. This is maybe 8 or 10 years ago, because I testify in a lot of public hearings, right? So I just wondered whether the courts ever paid any attention to anything I say, and so I went on Westlaw and I searched my name. And it was fascinating because I think I found like maybe a dozen sites and cases where judges had looked at legislative history and had pulled up some part of my testimony.
Oh, that's interesting.
I know why I did it, because in recent years, the legislature, in an effort to save money, started talking about not transcribing things, but so like, well, you know, they're paying lots of money to stenographers to type up the transcripts of public hearings, of, you know, all sorts of things, and then make it easily accessible. And there was talk about, well, what do we need? Why do we need this? Why can't we just put it on electronic tape and we'll save the tape? Well, who's going to be able to find things on the tape? And so at least part of that was I searched myself to find out how easy it would be to find legislative history, and so that was interesting. And then another time I was actually looking for legislative history on some bill, and I read the floor statement of the chair of the Judiciary Committee explaining a bill, and I'm looking at his speech because I didn't hear it. I didn't hear the speech. And looking at the speech, and I'm saying, this sounds really familiar. And what he was doing was he'd taken my public hearing testimony and he was reading it. Not in my name, he was reading in his name. So that was, you know, it was like my presentation made it into the legislative history, but under somebody else's name. It's like I'd ghostwritten for this guy, unintentionally. And so it goes back to saying that you actually have an impact. You can have an impact. So that's a reason to keep doing these things. That it actually the results turn out to be different because you're there. And that's not me in particular. This is true for everybody who does this. I'm not trying to claim special credit or special ability.
No, it seems like a theme that when I interviewed other legal aid attorneys, it seems like that is the common theme.
Yeah. I mean, people do litigation. And
they stay.
They do litigation and they make a difference
Right.
in somebody's life. They may make a difference in what the law is. I mean, people have, not me, but people have litigated cases in Connecticut that essentially changed the law for everybody.
Right.
Maybe even something like Bodie versus Connecticut, which leads to the whole fee waiver system, or I mean, there are things don't necessarily come to mind, but there are loads of things where that's true. So,
Great.
yeah.
Well, thank you so much. I appreciate
All right.
your time.